The Constitution really asserts the importance of the rule of law in a country's development. A country's development morally, economic development, its growth to an understanding of itself as an entity. And the Constitution, one of its principal values is the rule of law and the supremacy of the Constitution, which means that you subordinate all power, presidential power, parliamentary power, executive power, even judicial power is subordinated to the Constitution because the Constitution is supreme. So the new Constitution made a radical break from the past. Instead of embodying a legal system that subordinated people and oppressed them and enforced an iniquitous ideology, the Constitution became the embodiment of the country's highest aspirations for itself. It's a very lofty, aspirational, progressive, encompassing and ample-hearted document. And the Constitutional Court was specially created in 1994 when South Africa became a constitutional democracy to be the guardian of the Constitution. The Constitutional Court is now South Africa's highest court. An amendment was passed last year that gave the court also non-constitutional jurisdiction, which means it can take any case, even one that doesn't involve any high constitutional aspect. After 19 years, the court has a record, I think one can say, without either complacency or a lack of modesty, of asserting the rights in the Constitution, of standing in and taking a stand for the poorest of the poor, land claimants, urban tenants, people in the housing queue, people in desperate need of housing, of people with HIV and AIDS, like myself, someone living with HIV. The court gave a famous judgment in 2002 that asserted the rights of people under the right to health care to start receiving antiretroviral treatment.
Another area that occupied a lot of attention from the court was the area of enforcing social and economic rights. And I think it's fair to say our court was a pioneer in that respect. That's the right of health, the right of access to adequate housing, the right of access to education, to food, to water, basic human rights. And these were rights in our Constitution to be treated on the same basis as civil and political rights, the right to vote, the right to speak your mind, all important. And we developed, I would say, two doctrines that are now being picked up in other parts of the world on enforcing social and economic rights. We don't expect people to run to court to say, I have a right to a hospital bed. I have a right to a place at this university. There are other statutes dealing with the priorities and so on. But if the state fails to take measures that reasonably respond to the needs in particular areas, and bearing in mind the resource limitations, and bearing in mind these are things progressively realized, the court can intervene. And we did so in one very dramatic case, access to antiretroviral drugs, which many people regard as a turning point in South Africa in terms of the state response to the HIV pandemic.
We've been able to ensure that the idea of socio-economic rights as being a set of rights that are clearly justiciable, that can be decided on in a court without conflicting with things like separation of powers, without undermining an elected executive, but at the same time holding that executive to account. I think we've been able to lay that foundation, and I think there's almost, there are various parts of the world where the notion of being able to take issues that are around socioeconomic rights to be decided on by courts is fairly alien, whereas I think in South Africa it's actually now something taken for granted. And I think that the Legal Resources Centre, and particularly the Constitutional Litigation Unit of the centre have played a huge role in making that possible.
One of the most extraordinary things of the Constitution when it took effect in 1994 was a world first, which was the inclusion in South Africa's Equality Clause of two words that had never appeared before in any constitution in the world, the word sexual orientation. And the gay and lesbian community fought for their inclusion. I was involved in that struggle during the constitutional negotiations, and we succeeded in getting sexual orientation included in the Constitution. That led to a sequence of decisions by the Constitutional Court before I joined it, which enforced the right of equality for all gays and lesbians in the country.
When Atlantic entered the picture in South Africa in the early 2000s, I think it was at quite a critical moment in terms of the development of LGBTI activism and the LGBTI community in South Africa. So we'd seen the advent of democracy, and I think that really ushered in a whole new era of LGBTI thinking, LGBTI politics. And what we saw is a real commitment from LGBTI activists to advance an agenda of law reform. So in other words, to really take on the existing pieces of legislation that under apartheid had criminalized homosexual behavior and really take our constitutional principles of equality and dignity and make sure that they were appropriately reflected in all our laws and in all our policies in a democratic state. And so Atlantic's investment in that process, I think, was very significant, and it enabled LGBT activism to really take to the courts and take to the streets and ensure that we as LGBTI people could, in a sense, draw down on constitutional principles and values to ensure that we ourselves had equal citizenship under the law.
We have made use of litigation, and we've done so effectively, but always as a last resort. So we have always sought to resolve issues either directly by engaging with government, through meetings, through letters, through protest action, and we have made use of litigation, and we have sent letters on behalf of our lawyers in instances where that has been necessary. And that has proved to be effective, and that has been proved to be another lever and another tool in our work, very effective tool.
You know, that fight really began in about 2001, if you talk about the courts, because that was when we instituted litigation around preventing mother-to-child HIV transmission. You know, the highlight, if you like, was December 2001 when we won our first court case in the Pretoria High Court. The even higher highlight was July 2002 when we won the definitive TAC judgment ordering the government to roll out antiretroviral therapy. But again, you know, the history of the South African struggle around AIDS is not just about compliance with court orders, it's about contempt of court orders. So even when we had the 2002 judgment in our back pockets, government did not comply with the spirit of that order. So we had to continue to struggle.
There are a number of examples of very practical impact that the LRC's cases have made in terms of achieving material difference in hundreds and thousands of people's lives. One example of that, which is an example that saw us participating in 11 cases, would be the Richtersveld community, which is a community in a very remote part of the country, a desert area that had been dispossessed of its land in order to make way for diamond mining, and it had not benefited from those operations. And in the process of claiming its right for some form of restitution, the LRC was able not only to ensure that the community reasserted access to lands, some of those for agricultural purposes, some of those for housing, but also asserted the right of that community to benefit from the wealth, the mineral wealth, in the form of a shareholding, as well as getting monetary compensation. Now, there are obviously many things that one learns from those kinds of experiences, but the point I think that I'm making is that the investment of the time and the energy through the courts is not just a jurisprudence issue. It's about really affecting people's lives.
Section 27 went to court over the failure to deliver textbooks to certain classes of students in Limpopo province, which is in the north of South Africa. This was something that affected thousands and thousands of schools and hundreds of thousands of learners who by May did not have textbooks by May. That's 5 months into the school year. Now, you know, it's a long story. We went to court, we won in court, we got an order that the textbooks should be delivered, we got an order that there should be an organized plan to allow the children to catch up what they had lost by not having the textbooks. There was a huge political uproar around it. But, you know, what has amazed me in some ways, because it was unanticipated results, is really the kind of aftershocks, the ripple effects of that case. You know, that case led to a presidential task team investigating the national system for the procurement and supply of textbooks. It also led to a Human Rights Commission conducting its own public investigation into the procurement and supply of textbooks, and undoubtedly is going to lead to a situation within a year where there is stability and sustainability and access to textbooks for learners throughout the country.
The case that the Treatment Action Campaign and the Legal Resources Centre brought against the government in relation to access to drugs to counter HIV and AIDS through the public health system, that was a dramatic achievement. In effect, it has saved the lives of hundreds of thousands, if not millions of people. But other litigation has had very important impacts. So, for example, the Legal Resources Centre's case to have the Communal Land Rights Act struck down, which affects something like 16 million women in rural areas who are subject to the rule of traditional leaders and who, in terms of customary law, cannot inherit land, cannot own land. That law was struck down by the Constitutional Court, and the transformative effects of that we have yet to see, but it will change the lives of women in rural areas who will now be able to own land, inherit land, and enhance their livelihoods.
And so what Atlantic did was it allowed us as a new generation of activists and social justice activists and, you know, community organizers and public interest lawyers and researchers to actually build a new jurisprudence, which I think now when you look back is something that we, at that time, we took for granted. I mean, we were blessed with a new constitution. We immediately took that and started shaping a whole new socio-economic and civil political jurisprudence. And I think if it wasn't for Atlantic and Gerald in particular, the entire manner in which donors would engage with grantees would, I think, have been very different. The agenda would then have been set by the donor as opposed to the agenda being set by the grantee.